Hello and welcome to LiveLaw Daily. Today is the 17th of July and these are the biggest legal developments from across the country. From the Supreme Court to the High Courts, your daily no-noise roundup of the most important stories. So, let's begin. For our first story, the Jammu and Kashmir and Ladakh High Court has clarified an important principle on media liability, holding that a managing director cannot be held criminally responsible for the contents of a newspaper merely because of his designation. A bench of Justice Sanjay Dhar quashed a criminal complaint against Vineet Jain, the managing director of Bennett Coleman & Co Limited, which owns the Times of India. The court held that under the Press and Registration of Books Act 1867, the statutory presumption regarding responsibility for published content applies only to the editor and not to a managing director or any other office bearer. The complaint arose after a newspaper report mistakenly published the photograph of an engineer and social activist while reporting the death of an army soldier. The complainant alleged that the error damaged his reputation, exposed him to threats from different groups who believed he was associated with the army, and even led to social boycott at his workplace. Vineet Jain challenged the proceedings, contending that as managing director, he had no role in selecting or approving editorial content, and that publication decisions were entirely handled by the newspaper's editorial team. Agreeing with that submission, the High Court relied on the Supreme Court's decision in K.M. Matthew versus K.A. Abraham, observing that while there is no blanket immunity for a managing director, criminal proceedings can continue only if the complainant contains specific allegations showing that the person exercised control over the publication of the offending material. Mere designation, the court said, is not enough. The court also found that the ingredients of criminal defamation were not made out. It observed that the report had merely carried the complainant's photograph by mistake while correctly identifying the deceased soldier by name, adding that being mistakenly shown as an army personnel could not by itself be said to lower a person's reputation. The complaint and all consequential proceedings against Vineet Jain were therefore quashed. And for our second story today, the Bombay High Court granted the Union government time till July 29th to file its response in comedian Kunal Kamra's challenge to the Sahyog portal and amendments to the information technology rules of 2021. At the heart of the case is an amendment to Rule 3 Clause 1D, which Kamra argues allows government authorities to flag online content for removal through the Sahyog portal, bypassing the safeguards built into Section 69A of the Information Technology Act. According to the petition, the law requires the government to follow the 2009 blocking rules, which mandate issuing notice to the person or platform hosting the content and giving them an opportunity to respond before any blocking order is passed. Kamra contends that the Sahyog portal creates a parallel mechanism where content can effectively be blocked through executive coordination, without notice, hearing, or procedural safeguards, violating both natural justice and the constitutional guarantee of free speech. During today's hearing, Senior Advocate Navroz Sirvai, appearing for Kamra, pointed out that despite several opportunities, the union government had still not filed its affidavit. He told the court that the matter directly concerns Article 19(1)(a) of the Constitution and deserved an early hearing. Appearing for the centre, Additional Solicitor General Anil Singh sought time till August to file the government's reply. However, after hearing both the sides, the bench granted time only till July 29th. Kamra's petition also argues that the amended framework is manifestly arbitrary and violates not only Article 19(1)(a), guaranteeing freedom of speech and expression, but also Article 19(1)(g), which protects the freedom to practice any profession or carry on any occupation. And for a third story today, the Delhi High Court has granted one final opportunity to AAP National Convener Arvind Kejriwal, Manish Sisodia and Durgesh Pathak to file their responses in the CBI's challenge against the trial court order that discharged them in the Delhi excise policy corruption case. Justice Manoj Jain noted that despite being given several opportunities earlier, the three leaders had still not filed their replies. In the interest of justice, the court granted them 2 more weeks to do so, while making it clear that this would be the last and final opportunity. The hearing took place in the absence of the respondents, as lawyers were abstaining from work. Solicitor General Tushar Mehta, along with Additional Solicitors General S.V. Raju and D.P. Singh, appeared on behalf of the CBI. The High Court has now listed the matter on August 17th and 18th when it will begin hearing the CBI's arguments. Justice Jain also said that once the agency concludes its submissions, a schedule will be fixed for arguments on behalf of all the respondents, adding that the court expects the timeline to be strictly adhered to so that there is no further delay in the proceedings. The interim orders in the case will continue. The CBI is challenging the February 27th order of the trial court, which discharged 23 accused persons, including Arvind Kejriwal, Manish Sisodia, and BRS leader K. Kavita, while also making adverse observations against the agency's investigation. Along with the CBI's revision petition, the High Court will also hear the Enforcement Directorate's plea seeking expunging of those observations made by the trial court. And for our fourth story today, the Delhi High Court has directed the central government to ensure that social activist Sonam Wangchuk is clinically monitored every day, with any medical intervention required to improve his condition being carried out without delay. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Tejas Karya recorded the centre's assurance that government doctors and medical experts are already monitoring Wangchuk's health. Taking that statement on record, the court directed that his condition should be assessed daily and observed. Life of any citizen is precious and all efforts ought to be made by government authorities to save the same. The public interest litigation filed by Advocate Rakesh Kumar Saini had sought directions to shift Wangchuk to a hospital and administer medical nutrition during his hunger strike. After issuing the above directions, the High Court disposed the petition. Meanwhile, as Wangchuk's fast entered its 18th day, Supreme Court Bar Association President Senior Advocate Vikas Singh visited him at Jantar Mantar and publicly appealed to him to end the hunger strike. In an open letter, Singh said Wangchuk had already stirred the nation's conscience and urged him to conserve his strength for the larger battles ahead. Senior Advocate Kapil Sibal also made a similar appeal, saying that the country will need voices like Wangchuk's to continue leading public causes. Sibal further contrasted the government's response with the Anna Hazare movement, saying governments are expected to engage with the citizens raising issues of public importance, unlike the current BJP-led government. Sonam Wangchuk has been on hunger strike since June 28th, demanding the resignation of Union Education Minister Dharmendra Pradhan over alleged examination irregularities, including the NEET paper leak. And for our fifth story today, a consumer commission in Chhattisgarh has directed Maruti Suzuki to replace an entire vehicle after finding that the buyer was never informed that it was not compatible with E20 petrol. The case was filed by Dr. Devta, who purchased a Maruti Suzuki Grand Vitara Strong Hybrid in June 2024. Within 5 months, the vehicle began stalling repeatedly. Although the authorized service center initially attributed the problem to contaminated fuel and cleaned the fuel tank, the issue continued to recur. Dr. Devta then had the fuel independently tested. According to the report, the sample had developed a curd-like consistency, and a government-recognized laboratory confirmed the presence of ethanol. The commission found that the vehicle manufactured in January 2023 was not equipped with an E20 compliant engine. It held that the recurring defects were linked to the vehicle's inability to operate on petrol blended with 20% ethanol, and observed that neither Maruti Suzuki nor its dealer, Nexa Magneto, had informed the purchaser about this limitation at the time of sale. Accordingly, the District Consumer Disputes Redressal Commission of Raipur directed the manufacturer and dealer to take back the vehicle and provide a new E20 compatible model within 45 days. If they fail to do so, they have been directed to pay 20.5 lakh rupees, covering the cost of the vehicle, RTO charges and insurance. The commission also awarded 1 lakh rupees as compensation for mental agony and 10,000 rupees towards litigation costs with 7% annual interest in case of delay in payment. And for a sixth story today, the Uttar Pradesh police has informed the Supreme Court that it has found no evidence linking Ashish Mishra or his father, former Union Minister Ajay Mishra, to allegations of intimidating witnesses in the Lakhimpur Kheri violence case. A bench of Chief Justice of India Suryakant, Justice Joymalia Bagchi and Justice V. Mohana was hearing Ashish Mishra's bail matter, with the Supreme Court continuing to monitor the progress of the trial. During the hearing, the court was informed that the investigation into the witness intimidation allegations had been completed completed, and according to the status report filed by the state, a charge sheet has been filed against Amandeep Singh, and the competent court has already taken cognizance of it. However, the police concluded that Ashish Mishra, Ajay Mishra, and the other persons named in the complaint were not involved in the alleged intimidation. The Supreme Court recorded the contents of the status report and granted the complainant 2 weeks to file an additional affidavit in response. The witness intimidation case originated after the Supreme Court criticized the Uttar Pradesh police for not acting on a complaint by witness Baljinder Singh, who alleged that he was being threatened to withdraw his statement. Following the court's intervention, the police registered an FIR under sections 195A, 506 and 120B of the Indian Penal Code. The main criminal case relates to the October 3rd, 2021 Lakhimpur Kheri violence, in which 8 people, including 4 farmers, lost their lives after vehicles allegedly linked to Ashish Mishra ran over protesting farmers. Mishra continues to face trial in that case and remains on bail granted by the Supreme Court. And for a 7th story today, the debate over the CBSE's 3-language policy reached another courtroom today. This time before Justice B.V. Nagratna of the Supreme Court, who questioned whether introducing a 3rd language at the class 9th level places an unnecessary burden on students. The remarks came during the hearing of the Tamil Nadu government's appeal against a Madras High Court direction to facilitate the establishment of Jawahar Navodaya Vidyalayas across the state. Tamil Nadu has consistently opposed these schools, citing concerns over the 3-language policy they follow. Although the validity of the CBSE policy itself was not under consideration in this case, Justice Nagratna observed that the policy does not mandate Hindi as the 3rd language. When the state's council explained that the 3rd language becomes compulsory only from class 9th, the judge remarked that this is very bad. 9th standard is very stressful. Why do you introduce a new language in 9th? You introduce it in 6th. The bench also noted that the national education policy itself states that no language should be imposed on any state. During the hearing, Justice Nagratna asked the state, "You don't want Hindi, but if it's Sanskrit, what is the issue?" Drawing from her own schooling, Justice Nagratna recalled that students in her school began learning a 3rd language during middle school, observing that the earlier, the better. She said introducing an additional language at a younger age was more practical than doing so just before students enter the pressure of board examinations. It is worth noting that the CBSE's 3-language policy for the 2026-27 academic year is separately under challenge before another bench headed by Chief Justice of India Suryakant, which is scheduled to hear the matter next week. And for our next story, we have the release of the animated film Mahaprabhu Jagannath that has now reached the Supreme Court after the Odisha High Court stayed its nationwide release just a day before it was scheduled to hit the theatres. The controversy began after the film's teaser was released on June 6th. Objections were raised by the Sri Jagannath Temple administration, following which the producers screened the film for Puri's Gajapati Maharaja and members of the temple administration. They objected to what they described as an inaccurate depiction of Lord Jagannath's childhood, saying it was not supported by the Skand Puran or the Brahma Puran. Although the producers reportedly assured that changes would be made, the dispute eventually reached the High Court. Staying the film's release, the Odisha High Court observed that while artistic expression is protected, it cannot be permitted to hurt religious sentiments in a manner that could disturb public order, particularly with the Rath Yatra approaching. Challenging that order, senior advocate Devdutt Kamath made an urgent mention before Chief Justice of India Suryakant, seeking an immediate hearing before the scheduled release. The Chief Justice declined a same-day hearing, observing that such urgent hearings are generally reserved for exceptional matters such as death penalty cases, but assured that the matter would be listed the next day. Appearing for the filmmakers, Kamath argued that the film had already received CBFC certification, was intended primarily for children, and that the High Court's order, uploaded around 9 p.m. on the eve of release, would cause severe prejudice, with over 300 theatres booked and substantial investments already made. The Supreme Court is now expected to hear the challenge tomorrow. And finally, for our last story, the Rajasthan High Court has expressed serious dissatisfaction with the state's response in a case concerning the condition of women and children's shelter homes, calling the affidavits filed by officials nothing more than mere cyclo-styled documents. A division bench of Acting Chief Justice Sanjeev Prakash Sharma and Justice Sanjeev Purohit was hearing a suo motu case that began after children residing at a Balika Graha at Alwar wrote to the court, highlighting severe hardships allegedly caused by the state's failure to release grant and aid. During the hearing, the bench found that the affidavits submitted by the concerned officials did not comply with its earlier directions. The court observed that they were essentially identical documents with only the signatures of the respective officers differing, and remarked that such affidavits did little to assist the court in assessing the ground reality. The High Court has now directed the concerned officers to file fresh, district-wise affidavits detailing the actual requirement of Nari Niketans, Balika Grahas, Bal Grahas, and foster homes across Rajasthan. It has also asked them to place on record the present condition of each institution, supported by photographs so that the court can assess the existing infrastructure and facilities. The matter will now be taken up on July 20th, when the court is expected to examine the fresh affidavits and review the condition of these shelter homes across the state. And that's a wrap for this episode of LiveLaw Daily. You can find links to all the stories we covered in the description box below. And for complete reports and continuing coverage of these cases, visit livelaw.in. Until next time, and keep following LiveLaw for everything that is law.